Thank you, Mr. Speaker. Mr. Speaker, I beg to present for second reading a bill shortly entitled Criminal Code Amendment. Mr. Speaker, I'm very pleased to present this bill, as this bill seeks to reduce the backlog in criminal cases in the criminal justice system in St. Lucia. But let me begin my presentation by just doing a few explanations exactly what is a judge alone trial. And we have students present. I will take some time to explain exactly what the bill entails. A judge alone trial, Mr. Speaker, is a trial in which a judge sitting alone determines questions of fact and law and is empowered to determine the guilt or innocence of an accused person. Now, judge alone trials, Mr. Speaker, they've been around for a very long time. It's not something new. There are countries in the world that do subscribe to judge alone trials. England, Wales, Northern Ireland, Canada, New Zealand, some of the Australian states, New South Wales, Queensland, Western Australia, the United States of America, India, South Africa. Here in the region, we have Antigua and Barbuda, Jamaica, St. Kitts and Nevis, Cayman Islands, and Belize. Now, why judge alone trials? Why would you want to proceed with the judge alone trials when traditionally we have a judge and a jury trial, which have been around for 800 years? Why do you want to judge alone trials? Well, judge alone trials would be suited for certain types of cases. You may have a high-profile case, a serious case, a murder trial, a long and complex case which involves technical evidence. You may have a case which engenders pre-trial publicity. Graphic evidence may be led in a trial. You may have allegations of intimidation or threat to jurors or bias. So you may want to have a judge alone trials. Of course, there have been skeptics as to judge alone trials. And even myself, coming from the defense bar, when I first heard of judge alone trials, I was a bit skeptical because I like the judge and jury. But over a period of time, you get into it, you realize, yes, it's something that I would consider, and I could see the benefit to the criminal justice system of St. Lucia in terms of the reduction of the backlog of cases. Now, I want to put on the record, Mr. Speaker, that the criminal division of the High Court continues to struggle with a significant backlog of criminal cases, and they are unable to dispose of those criminal cases in a timely manner. On average, cases get stuck in the system and may take a couple of years before actually coming to trial. The statistics that have been conducted suggest that countries that have introduced judge alone trials have seen a significant reduction in those cases. Now, in the bill, we have put the election, the defendant can elect to be tried by a judge alone. So he has that option to say yes or no. The consent of the defendant is required. Now, we have left it wide open in St. Lucia, wide enough to cover all indictable offenses. That scenario exists in Trinidad and Tobago and the Cayman Islands. In some jurisdictions, there's a schedule which provides some offenses to be tried by judge alone trials. For example, some jurisdictions may say larceny, receiving stolen property, fraud offenses, corruption, possession of firearms, drug offenses, unlawful possession. They suggest in a schedule some of those offenses should be tried by judge alone. They don't want all the offenses. But in St. Lucia, we've decided to elect for all the offenses. Of course, the prosecution themselves may apply to the court for a judge alone trial. The prosecution may consider that a particular case, in that particular case, there's a danger of jury tampering, intimidation of witnesses, a material witness is afraid or unwilling to give evidence before a jury. The case itself involves a criminal gang element. They make that application to the court for a judge alone trial, or the complexity or the length of the trial is likely to be burdensome to the jury. So the prosecution may make an application to the court to basically have a judge alone trial. In our scenario, if the prosecution decides to do that, of course, both sides can make representations to the court. Prosecution would say, yes, this is the reason. The defense would have the opportunity to say no. Now, there's nothing to fear a judge alone trial. The structure of the trial by judge alone remains the same as a trial with judge and jury. So you have your opening speech, prosecution calls the witnesses, defense cross-examines, you have the close of the prosecution case. If the defense decides to make a no-case submission, that continues. If rejected, the defense is called upon to answer. Defense may be entitled to testify or remain silent. You have addresses and a decision by the court. The same rules of evidence apply. The judge addresses the issues of admissibility, and of course the parties, prosecution, defense, may be called upon to make submissions, argue any legal issues that may arise. Now, the judge, on the conclusion of that judge alone trial, the judge delivers his decision for either the conviction or an acquittal. Now, the judge is mandated to deliver his decision and give a written judgment stating his reasons. And I address the court, Mr. Speaker, the attention to section 923 at page 14 of the bill, which basically says in St. Lucia, the judge is mandated to deliver that written decision within 24 hours. And of course, that written decision would include the principles of law, the findings of fact on which the judge relied upon. Of course, if the judge fails to deliver his decision within the specified period, he should inform the parties that he required of the time required for the completion. And of course, nothing has changed in relation to criminal appeals, powers of the Court of Appeal, same powers in relation that the court has in relation to judge and jury, court has in relation to judge alone trials. And again, in the region, Antigua, Barbuda, Belize, Cayman Islands, Jamaica, St. Kitts and Nevis, Trinidad and Tobago have judge alone trials. What are the advantages of a judge alone trial? Why would you want to have judge alone trials? Apart from the reduction of the backlog statements, cases, tendering of witness statements, expert evidence, the deliberation process is streamlined for counsel, no risk of disruption from absent jurors, flexible sitting hours, streamlined cross-examination, reduces the backlog, creates a more expeditious criminal justice system, saves expense, may be best for long and complex cases. Jurors may be influenced by improper evidence, even if the judge tells them to disregard it. Guards against the jury's exposure to pretrial publicity, less formal, making it feel less intimidating than jury trials. Avoids prejudice that a jury may bring to the trial process, race, gender, religion, gruesome nature of the crime, impartiality, no diversity. And of course, some defense lawyers may say, you know what, I've lost the opportunity to address the jury. Defense has lost the opportunity to address 9 or 12 persons. You have the judge, so all the histrionics you may have before the jury, you don't have that before a judge. The judge is impartial, the judge basically deals with the evidence. That's one of the things that I myself was a bit concerned about. I like addressing the jury, but if you're addressing a judge, a lot of whatever you may say to the jury, the histrionics, as Justice Saunders once said, you do not have that before a judge. The judge is basically just strictly facts and law. Now, the fear of more convictions under judge alone trial, I want to dispense that. The statistics suggest in New South Wales that between 2009 and 2014, there were higher acquittal rates for judge alone trials. And of course, again, advantage, no jury expenses, streamlined opening closing address, and trial less likely to be aborted. Now, in our bill, we've put a particular provision in our bill that emanated from, that was raised, and we took note of it in the case of Sean Campbell and Adidja Palmer, Vibes Cartel, which was delivered in the Privy Council in 2024, 15th of February 2024 at the UK Privy Council. took note of that at paragraph 54, where there may be a danger in long trials, long and complex trials, the danger of deliberate attempts to derail a criminal trial, in particular at the closing stages, by the defense, by engendering situations in which it becomes necessary to discharge the jury. So you have a long and complex trial, months of evidence taken, months of court time has been invested in a particular trial, and then jury tampering occurs. You don't have the provision. Basically, you have to start all over again. In England and Wales, there is legislation that provides in certain circumstances it is permitted to discharge a jury because of jury tampering and to continue the trial without a jury, but by the judge alone. We looked at that particular ruling in terms of England and Wales, and we have incorporated that in our legislation to avoid a situation like that. New section 974A, discharge of jury as a result of jury tampering. It's at page 11 of the bill. Section 974, page 11 of the bill. Now, I recently attended an inaugural Attorney General's Roundtable discussion in Barbados, where judge-alone trials and plea negotiation featured. And they were both discussed because they provided viable solutions to the challenge of case backlogs in the criminal justice system. My colleagues, we all discussed it. From St. Kitts and Nevis, Barbados, Guyana, Dominica, we all discussed judge-alone trials. And I've said a lot of the colleagues at St. Kitts, Barbados, I think, has had only 2 judge-alone trials. St. Kitts has, they have it. Guyana, I think they're looking to introduce it. And as a result of that engagement, I want to thank the facilitators who basically helped us, the material. I want to put on the record and thank Honorable Madam Justice of Appeal Alice York Suhan, President of the Court of Appeal, Turks and Caicos, and the Honorable Madam DPP Paula Llewellyn, Senior Counsel from Jamaica, for the resource material, the presentation, which I'm using it as part of my presentation here today, to thank them for their input, and I want to thank them for the guidance in basically assisting us in presenting this particular bill. And I also want to thank all the relevant stakeholders for their input and the guidance in the drafting of this bill. And of course, for their patience. It's something that we wanted to do, but we wanted to get it right. We wanted to get the sections correct. So I thank the stakeholders for their patience. And Mr. Speaker, I conclude, and I ask this honorable court, this honorable house, to give due consideration. I guess I missed the court. I ask this honorable house to give due consideration to this bill. Thank you, Mr. Speaker.